A Lubbock woman's lawsuit over utility shutoffs is now in a new phase after the city and an electricity company asked a judge to throw out parts of the case. The woman argues her civil rights claims should stay in court.
KCBD News Channel 11's investigative reporter Shaylee Kidwell has followed this case since January, and she brings us the latest on what happened in the courtroom today.
Today's hearing focused on a basic question. Does this court have the power to hear this case? According to court filings, Maria Jesus Tucker says her electricity was shut off in January right before severe winter weather because her landlord didn't pay the bill. LP&L says Ambit Energy Texas, the retail electric provider on the account, requested the disconnect for non-payment. Tucker worked with attorneys at Legal Aid of Northwest Texas to ask 99th District Judge Philip Hayes to order power restored before temperatures dropped. The judge ordered the power to be turned back on under the dangerous conditions. Tucker has filed a lawsuit against the Lubbock mayor and council, LP&L, Ambit, and others, arguing tenants need more notice and a real chance to keep service on. Tucker says she offered to pay the electricity bill directly to Ambit, but couldn't because her landlord was the customer on the account. LP&L's attorney told the court the property was not individually metered, so paying would have meant paying for electricity used by other tenants on the property as well. LP&L says it sympathizes with Tucker's claims against her former landlord, Thunder Sun. However, LP&L says Tucker's constitutional claims against it depend on a key assumption it says is wrong, that LP&L generates and provides power directly to customers and can control billing or payment-related shutoffs. LP&L says it does not. Attorneys for LP&L and Ambit argued the dispute is really about electric disconnection rules and that Texas law puts those issues under the Public Utility Commission, not a district judge. In its statement, LP&L says that after Lubbock's transition into the retail electric market and ERCOT, it's bound by statutes and regulations and says complaints about notice requirements belong at the Public Utility Commission. Tucker's attorney, Benjamin Gerzik, with Legal Aid of Northwest Texas, disagrees, arguing this is a constitutional civil rights case that belongs in court.
Right. It's asking the question of whether an innocent tenant, when they're willing to pay their bills and avoid utility disconnection, as is their right under the statute and the Constitution, it's asking whether a purely constitutional lawsuit goes to a court or to the Public Utility Commission, which isn't allowed to ask constitutional questions.
LP&L also calls the claim against it and its employees frivolous and says it will vigorously defend the case, arguing baseless claims would ultimately be borne by ratepayers. Ambit's attorney declined to comment. Gerzik wants other tenants who may be in a similar situation to know they have rights.
I want them to know they have rights not just under the property code, but under the Constitution, right? And if a landlord or the government or a private utility chooses not to respect those rights, they better be ready to fight like hell.
The judge did not make a ruling today, but is expected to do so in the coming days. Shaylee Kidwell, KCBD News Channel 11.